Hello everyone, and welcome to the June 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is Anna Maria Sandoval versus Farmers Insurance Exchange, Henry Ford Health System, and Valdimir Boshevski and Zurich American Insurance Company, which is an unpublished opinion per curiam of the Court of Appeals that was issued on May 9th, 2025. The second case law update that will be discussed is on Michigan Head and Spine Institute, PC, and McLaren, Macomb, and Daniel Crane and Regents of the University of Michigan versus Nationwide Mutual Fire Insurance Company, which is a published decision from the Court of Appeals that was issued on May 15th, 2025. Lastly, we will focus our discussion on the trending topic in PIP litigation of opt-outs in PIP coverage. I will first give you an overview of the topic and the effect that opt-outs have had. Second, we will discuss the recent unpublished opinion per curiam of the Court of Appeals that was issued on April 15, 2025 of Tiffany Carroll and Kayla Carroll versus Progressive Michigan Insurance Company and Allstate Insurance Company. The first case we are going to discuss is the unpublished Court of Appeals case of Sandoval versus Farmers Insurance Exchange et al., which is a case that was consolidated with a provider action. This case discusses specifically a motor vehicle accident involving a shuttle bus and the application of the primary purpose / incidental nature test. This case also has Michigan Assigned Claims Plan involvement. In this case, plaintiff Sandoval was riding as a passenger in a shuttle bus owned and operated by Henry Ford Health System, driven by defendant Boshevski and insured by Zurich American Insurance Company. When Boshevski made a turn, Sandoval's wheelchair came loose and she fell onto the floor, sustaining injuries. After the accident, Sandoval submitted a claim for PIP benefits through the Michigan Assigned Claims Plan, which assigned Farmers Insurance Exchange to the claim. Sandoval subsequently filed a PIP suit against Farmers. Sandoval also assigned and transferred her rights and interests to other plaintiffs, Tox Testing, doing business as Paragon Diagnostics, Pro Toxicology Testing, and Detroit Metro RX, who in turn filed suit against Farmers in a separate action. Farmers asserted in both actions that it was not responsible for payment of Sandoval's PIP benefits because Henry Ford's no-fault insurer was a higher priority insurer, which was Zurich. Sandoval thereafter moved to amend her pleadings to add claims against Zurich, Henry Ford, and Boshevski, and the trial court granted the motion. As relevant to this appeal, Zurich, like Farmers, asserted in response to Sandoval's complaint that it was not the highest priority insurer. Farmers moved for summary disposition under MCR 2.116C10, claiming that Sandoval was not eligible for PIP benefits through the MACP because she was entitled to benefits from a different source, which was Zurich. According to Farmers, Zurich was required to pay Sandoval's PIP benefits under MCL 500.3114 subsection 2 because Sandoval was injured while, quote, a passenger of a motor vehicle operating in the business of transporting passengers, unquote. Farmers further argued that the exception for nonprofits in MCL 500.3114 subsections 2D did not apply because Sandoval was not entitled to PIP benefits under any other policy. Zurich argued that the shuttle bus was not operated in the business of transporting passengers under MCL 500.3114 subsection 2 because the shuttle bus service was an incidental or small part of Henry Ford's primary business function of operating an entire healthcare system. Farmers was granted summary disposition by the trial court in both actions. Defendant Zurich appealed the decisions in each of the two actions and further argued that Zurich was entitled to summary disposition. The central question that the Court of Appeals was asked to address was whether Henry Ford's involved shuttle bus was a motor vehicle operating in the business of transporting passengers under MCL 500.3114 subsection 2, and thus an exception to the general order of priority contained in MCL 500.3114 subsection 1. The Court of Appeals then applied the primary purpose/incidental nature test to determine whether at the time of the accident a motor vehicle was operating in the business of transporting passengers pursuant to MCL 500.3114 subsection 2, which was discussed in Farmers Insurance Exchange versus AAA of Michigan back in 2003. This test asks the following relevant questions. 1. Whether the transportation of passengers is the primary purpose for which the vehicle is used. And 2. Whether the transportation of passengers is a primary, as opposed to incidental, component of the overall business or activity of the operator. In this present case, it appeared to the court that the parties agreed that the involved shuttle was primarily used to transport passengers. However, they disagreed about whether the transportation of passengers was incidental or a small part of Henry Ford's overall business. Zurich's argument was that because of the large size of Henry Ford's operations, its shuttle bus service, consisting of only 12 buses operating within 1 square mile, is only a small part of their business. On the other hand, Farmers argued that it is unknown how many employees or patients of Henry Ford actually utilized the shuttle buses, and that the demand was high enough to at least call for 12 buses. Overall, the Court of Appeals found that the trial court erred when it found, before the close of discovery, that there was no question of material fact that Henry Ford shuttle bus service was more than incidental or a small part of its operations. It found that a grant of summary disposition as to either party at this time was improper. The priority dispute between the two carriers was then remanded back to the trial court for further proceedings. The second case that we will discuss is the published Court of Appeals decision issued on May 15, 2025, of Michigan Head and Spine Institute PC, and McLaren Macomb and Danielle Craig, and Regents of the University of Michigan versus Nationwide Mutual Fire Insurance Company, which is another consolidated action. This particular case involves the interpretation of the term medically indigent and apportionment of the available PIP benefits under MCL 500.3112 and MCL 500.3142 and the first in, first out basis. On January 7, 2021, Plaintiff Crane was driving his girlfriend's vehicle at a high speed when he lost control of the vehicle, which then struck a guardrail, went airborne, hit a parked vehicle, and crashed into a building. Crane was transported by ambulance to McLaren Macomb Hospital, where he was treated before his transfer to Royal Oak Beaumont Hospital for further treatment by Michigan Head and Spine, including multiple spinal surgeries. After his discharge from Beaumont, he was admitted to University of Michigan Hospital for further treatment. As a result of his injuries, Crane is partial quadriplegic. Crane applied for coverage under the Michigan Assigned Claims Plan, having no coverage. On February 19, 2021 and April 9, 2021, Crane's providers submitted claims to the MAIPF for payment under the MACP, and Nationwide Mutual Fire Insurance Company was the assigned carrier. After their bills were refused by Nationwide, the providers submitted their bills to Medicaid and received payment. Crane filed an action against Nationwide seeking PIP benefits. Crane's providers filed a separate lawsuit also seeking benefits, and the trial court consolidated the cases. Thereafter, Nationwide filed a motion to interplead $250,000, which is the statutory maximum for PIP benefits under the assigned claims plan under MCL 500.3172 subsection 7A and MCL 500.3107C subsection 1B. Nationwide argued that the provider's claims, Crane's claims for attendant care benefits, and a Medicaid lien exceeded the statutory maximum of $250,000. Nationwide requested that the court grant its motion to interplead, allow it to tend $250,000 to the court for apportionment under MCL 500.3112 and discharge it from its statutory duties. The trial court granted Nationwide's motion to interplead, and it apportioned the benefits due under the No-Fault Act. The trial court first found that Crane was, quote, medically indigent, unquote, as defined in the Social Welfare Act, found in MCL 400.1, They found this because his medical expenses for his catastrophic injuries far exceed the maximum statutory PIP benefits to which he is entitled. The trial court then awarded 90.7% of the benefits to Crane and 9.3% to the providers, finding that, quote, to be an equitable apportionment of the extremely limited funds available following this catastrophic accident, unquote. Crane's providers later appealed the trial court's decision. The court noted that a medical provider's acceptance of a mistaken payment of Medicaid benefits on behalf of a plaintiff does not release the plaintiff from his or her, quote, responsibility for the medical expenses incurred but not paid for, nor does it bind the providers to limit their claim to the statutory amount allowed for Medicaid benefits, unquote. And this was under the Hicks versus Citizens case from 1994. As a result, resolution of this issue turns upon whether Crane was or was not entitled to Medicaid payments at the time that the providers received the payments from Medicaid. The court further notes that Medicaid assistance is available to the medically indigent, per Botsford General Hospital versus Citizens, a 1992 case, citing MCL 400.105 subsection 1. By statute, a person is medically indigent if the need for the type of medical assistance available under this act, for which the individual applied, has been professionally established and payment for it is not available through the legal obligation of a public or private contractor to pay or provide for the care without regard to the income or resources of the patient. And that's under MCL 400.106, subsection B2. The availability of PIP benefits under the MACP renders a plaintiff medically non-indigent and therefore ineligible for Medicaid benefits, and that's under the Hicks case. Crane argues that Hicks and Botsford are inapplicable because at the time that they were decided, PIP benefits under the No-Fault Act were unlimited. He suggests that because there are finite benefits available and because his medical expenses for his catastrophic injuries far exceed them, he should be considered medically indigent. The Court of Appeals points out that at the time the providers received payment from Medicaid, Crane's PIP benefits had not been exhausted. The court found that the trial court would not have been able to order a distribution of PIP benefits to either Crane or the providers if such medical benefits were not available to Crane. Thus, because Crane, quote, was entitled to medical assistance available through a legal obligation of a contractor, public or private, he did not qualify as a medically indigent person under MCL 400.106 subsection 1B2, unquote. The court found that the trial court erred in this regard. The providers also argue that the trial court erred in its interpretation of and application of the No-Fault Act. Because the statutory maximum of no-fault benefits available are limited to $250,000, and because the claims submitted to Nationwide exceed that maximum, the question is how the available funds should be dispersed. The court held that because MCL 500.3112 authorizes the trial court to apportion the available PIP benefits, and because MCL 500.3142 does not require payment on a, quote, first in, first out, unquote, basis, the trial court did not err in this regard. But as to the award of the PIP benefits for future attendant care, the No-Fault Act does not authorize payment of PIP benefits for losses that the injured person has not yet incurred. The court reversed in part the trial court's order apportioning the available PIP benefits and remanded for an equitable apportionment under MCL 500.3112. Finally, I wanted to discuss the trending topic in PIP litigation of opt-outs and PIP coverage and a newer case on that topic. The 2019 reform of the No-Fault Act allows persons with qualified health coverage to voluntarily opt out of PIP allowable expense coverage, but only if certain statutory conditions are met under MCL 500.3107D. Which include 1. The insured must sign a separate form approved by the Director of Insurance and Financial Services, or DIFS, and 2. Submit evidence that the applicant's or named insured spouse and any relative of either that resides in the same household have qualified health coverage. If any of these conditions are not met, then the opt-out is not considered an effective election. If the election is ineffective, then under MCL 500.3107D subsection 4 and MCL 500.3107C subsection 1D, the policy is considered to default to providing unlimited PIP allowable expense benefits. This allowance of Michigan policyholders to essentially choose their own coverage has become a game changer in our field, and there have been issues pop up in litigation mainly due to a carrier's issues with proving an effective opt-out by, for example, collecting documentation from an insured to confirm qualified health coverage. With that, I wanted to bring up the recent unpublished opinion per curiam of the Court of Appeals that was issued on April 15, 2025 of Tiffany Carroll and Kayla Carroll versus Progressive Michigan Insurance Company and Allstate Insurance Company. This case pertains to specifically the validity of electronic signatures on the PIP opt-out form and failure to timely submit proof of qualified health coverage. The facts of the case were that a September 2020 accident took place in which plaintiff Tiffany Carroll was driving her husband's vehicle, which was insured by Progressive Michigan Insurance Company. Accompanying Tiffany in the Trailblazer was her adult daughter, plaintiff Kayla Carroll, and both women sustained injuries as a result of this accident. After the accident, Tiffany sought to collect PIP benefits from Progressive, who denied coverage on the grounds that the insured had opted out of PIP coverage for allowable expenses under the policy. About 2 months prior to the accident, the insured completed an electronic application for his Progressive policy. He listed himself as the named insured and Tiffany as an authorized driver. Their daughter Kayla was not listed as a driver or resident relative, and their other daughter, Delisha, who lived with them, was listed as an excluded driver. At the time the insured submitted the electronic application, Tiffany had obtained health insurance for her family from her employer. Based on her qualified health coverage through her employer, the insured sought to opt out of PIP coverage for allowable expenses in his application. He placed his initials on the line corresponding with option 4, providing $250,000 in PIP coverage per person per accident with exclusions. After selecting option 4, he listed himself, plaintiff, and Delisha as persons with qualified health coverage, excluded from PIP medical coverage on the policy. He further provided an electronic signature following his opt-out option selection. The insured's wife argued that the insured could not have opted out of the PIP coverage for allowable expenses at the time he purchased the policy from Progressive, because Progressive did not receive proof of the qualified health coverage until November 18, 2020, which was approximately 2 months after the accident occurred and 4 months after the policy was purchased. Progressive moved for summary disposition, arguing that because it never received premium payments from the insured for PIP medical coverage, it did not assume the risk of covering those expenses, and therefore cannot properly be held liable for those benefits, and further argued that the insured properly opted out of PIP coverage. The Court of Appeals held that the insured had properly opted out of PIP coverage for the allowable expenses, and thus his wife was not entitled to coverage under the policy. The court found the insured's electronic signatures to be valid and noted that he received the benefit of his bargain by paying lower premium payments. The court agreed with Progressive that his signatures on the opt-out form were valid, and it noted that the insured used a third-party software called DocuSign and included his initials and full name throughout the insurance application. This is an electronic signature as contemplated by the Uniform Electronic Transactions Act. Under the terms of the application, the insured, quote, acknowledged that his electronic signature had the same legal effect as his written signature on a paper version of the document, unquote, and that it was, quote, valid evidence of his intent to enter an agreement with Progressive and, unquote, legally binding. The court found that the insured's lower premium payments were further evidence of the validity of the e-signed contract. Finally, as to the effect of Progressive's failure to timely verify his qualified health coverage, the court declined to invalidate an otherwise valid opt-out because of a 4-month delay in obtaining qualified health coverage that was valid at the policy inception and all relevant times thereafter. The court ultimately reversed and remanded to the trial court. I think that we're going to continue seeing cases such as this where carriers are forced to go on the offense as to an insured's own PIP opt-out selections and choices. That concludes the June 2025 edition of My PIP Monthly. If you have any questions, comments, and or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law and trending topic in the PIP world. Take care, everyone.